explained that very clearly. I think I explained it actually to both sides during the couple of final settlement conferences that we had. So I don't know why it's being raised. They have elected throughout these number of years to have the case remain here. So at this point, I'm not removing it. What, do we have everybody from Pittsfield PD here? Does Pittsfield have anybody on the road? I mean, I'm just thinking. Yeah, everybody's here. You guys take care. Thank you, Mr. Tiller.
Thank you.
Mr. Tiller, can you approach on a separate? Court does call the case of Finney versus Sidoni. The first thing, you guys are going to have to switch sides. Get your appearances, please.
Good morning, Your Honor. This is Megan Dogwalla on behalf of the plaintiff, P4205. You want to state your name? My name is
Peterson.
All right. Date set some time ago for a non-jury trial. Are the parties ready to proceed?
Your Honor, may I approach the bench and go off the record briefly before I begin? I have a procedural issue.
A procedural issue?
Yes. Stay on the record.
That's right.
May I-
What? No, well, then I'm going to have them up here. I guess, what is it?
Okay, so there is a counterclaim, which is separate full trial. There was already an order of eviction entered. I'm intending to move for summary disposition under C8 and C10. I need the opportunity to brief that issue.
Right out of the gate, the judge isn't buying the timing of this argument after years of litigation. Showing up on the morning of trial asking for dismissal and delays is always going to be a tough sell. Have you ever seen a judge look this skeptical this early in a hearing?
Well, why am I here on the date of trial with that?
Right. So the last motion that was filed, it was back in July. I appreciate that this is a long time coming. So please, Your Honor, I do not appreciate that for its time. However, I'm recently retained, and there's about 1,000 pages worth of evidence. This is gone to mediation. There's conflicts in the facts even in what was submitted during mediation, and there's significant evidence indicating issues of fraud on the court and other issues regarding insurance fraud by the defendants. And it is my professional opinion that it does substantiate claims under MCR 2.116 C8 and C10.
Well, the motion should have been brought before today. I mean, I don't know what particular issues you're talking about in terms of somebody committing fraud upon the court. And I'm just going to say this, if they were going to say this about the other side, if you're going to make that accusation, counsel, you better bring it. And it better be that, because if it's not, then I'm going to be exceedingly angry, because I do not like people accusing others of things like that without substantial proof.
Absolutely. It is a substantial issue in this case. My client's rights have been significantly violated. It's been
By whom?
by former tenants. This started out as a non-payment rent case. As I mentioned, there was an eviction action. There was an order of eviction. As you're aware, we're here on the bench trial for the counterclaim. I don't take a claim of fraud lightly. There is significant evidence to present that. And I don't want to disparage my client's rights by not attempting to have this dismissed under C8 and C10.
Well, I get it, but there was an attorney in this before.
He's exceedingly difficult to get a hold of. That was part of why I asked to approach the bench, but I
He's
understand
been
your
held
side.
up. He was in court here Monday, so I don't know why he's not that difficult to get a hold of.
Okay.
Coming in on the date of trial, asking for an adjournment of these proceedings is not going to happen.
Okay.
So you guys either can try to resolve this thing, or we're going to try.
Okay. Fair enough. Then I would request a brief recess to please speak to the defense.
Okay. See if you guys can work it out. Court's going to stand in recess.
14A District Court back in session, the Honorable Chase Henderson.
You may be seated. Back on the record, court does call the case Finney versus Sedona. All the parties are present. And how did the conversation go?
It wasn't entirely productive. So we have back from 2021 sent order for conditional dismissal, realized an eviction order entered after that time against the defendants. As it relates to today's full bench trial, it is based on a counterclaim that was filed on February 12th, 2021. However, again, it's my position that the counterclaim needs to be dismissed. There's not actual cognizable claims under the counterclaim, so that it would be right for dismissal under MCR 2.116C.
Why are they not cognizable claims?
The claims are not cognizable as
That warning from the judge is a huge moment. Accusing someone of fraud in court is serious business. Judges expect evidence, not speculation, and making those claims without proof can damage a party's credibility almost instantly.
defendants are now broker in this case. This was filed by their previous counsel. There is not a cognizable claim in regard to the condition of the property as against my client for relief.
Why is that not cognizable?
Can you repeat the question?
Why is that not cognizable claim?
It's not a cognizable claim, Your Honor, because there is a conditional dismissal entered as it relates to the original complaint where the defendants were being sued for the non-payment of rent, where the counterclaim asserts a generalized claim without any sort of reference to a breach of habitability or constructive eviction. The way that it's written in this counterclaim, it's more pertinent to the affirmative defenses, given the case history here and the fact that there was an eviction order entered. At this time, this can't be a cognizable claim before the court.
That doesn't even make any sense. If somebody says I paid $1,000 or rent was $1,000 a month, I didn't pay the $1,000, and actually I was living in conditions that I think the landlord may owe me money because I paid them or something happened to the unit. The very fact that there was an agreement to vacate the premises doesn't negate their claim for money. As it wouldn't the landlord, if the landlord had a claim for money.
Absolutely, Your Honor. My point is more towards, to back up slightly, it's been in court for a long time, there's a lot on the record, especially for something that started out as a non-payment of rent case. The defendants are the relatives of the plaintiff.
I'm aware of a whole lot.
There are facts in the counterclaim that are very generalized. There's not a factual section or actual things after that. Um,
Notice what the judge keeps asking for here: legal authority. It's not enough to repeat that a claim isn't valid. You have to explain exactly why and support it with law. This exchange shows the difference between making an argument and proving one.
it's very generalized, but it does assert that there's a dispute as to mortgage payments. There's a dispute as to ownership interest. So this is out of the realm of a landlord-tenant non-payment rent. And it's not a recognizable claim under the statutory law for those damages. Secondly,
You keep saying that. Give me some case law that says that.
Okay, I'm going to move on to a second point briefly and return to that, Your Honor.
Go ahead.
Okay. Secondly, after the generalized facts in the complaint, then the defendants move on to enter under a claim of statutory conversion, common law conversion, excuse me. Well,
Regarding the insurance line.
it's both. In paragraph 28, it's combined into common law conversion and conversion under MCL 600.2919A. Now, again, of course, Your Honor, we're considering what the language actually is in the counter complaint, but it's to my point that these claims are entirely but they're asking for, as you would be entitled to under statutory conversion, 3 times the amount of actual damages plus costs and reasonable attorney's fees. If there's no summary proceedings to be had in terms of the possession of the property, and what's at issue here are ownership interests and statutory conversion claim that exceeds $25,000, it's in the beginning, as I was arguing to you, this would be appropriate for dismissal under NCR 2.116C7. However, even if
Jurisdictionally or under 7? Why under 7?
right, this is what I'm stating, Your Honor. In the beginning, maybe it wasn't helpful to move on to a different issue, but in the beginning, it's that there aren't recognizable claims that apply any longer, given the procedural history. Not only that, but also just the way that it's been written out here in terms of the habitability. I didn't give a brief consult my information, but in terms of the habitability, the actual counts that would indicate that the legal requirements have been met are not enumerated. And then secondly, it would be appropriate under NCR 4.002, not necessarily to dismiss the action, but if it's related to property ownership, which is quiet title, and if it's related to conversion for a claim of over $25,000, it's not the court's obligation to dismiss it, but it would be more proper that this be transferred to the circuit.
And have you asked for removal?
I would request a removal, Your Honor.
I'm not removing this case. I think it was, and you coming late to the game, I think I explained to the Sidonis I don't have jurisdiction over the title.
Okay.
I also explained to them that my jurisdictional limit was $25,000. I explained that very clearly. I think I explained it actually to both sides during the couple of final settlement conferences that we had. So I don't know why it's being raised. They have elected throughout these number of years to have the case remain here. So at this point, I'm not removing it. Anything else?
I mean, I have to object to proceeding on a full hearing at this time.
On what grounds?
The numerous reasons I stated.
You stated a lot of gobbledygook is the only way I can explain it. You haven't given me a reason. You haven't given me a reason why it shouldn't proceed today. This matter has been set for trial today. I have given a lot of leeway to both parties, I think, in terms of trying to make sure to try to resolve this case, to try to find a way to do it, sent them to mediation. They went through basically a mediation with me regarding this case on a couple of occasions. And it's come down to the date of trial. And now you come in wanting further delay. And I'm not delaying this.
It's not that at all, Your Honor. I just want to do right by my client. I was hoping I could approach the bench. I understand there's not another attorney and a party also have to. But I'd like to go off the record for a moment if it's acceptable to you.
Do you have any objection to that, folks? No. Okay. I don't know how we're going to have this conversation, but let's do it this way. We can go off the record. Mr. Trapp, take both parties, behave yourself when you're in my hallway, take them back to the jury deliberation room. When you're seated in the deliberation room, I don't want either one of you saying anything to anybody until I get there. We clear? Ma'am, am I clear, Miss Finney? All right, take them back to my jury deliberation room. And the court will stand in recess. My understanding is the parties have had further discussions. Did anything come out of that? Still? Sure.
When we came back in, she asked us to step out in the hallway, and when we stepped out in the hallway, she proceeded to tell us that pretty much if we don't take up $5,200 in escrow all the way today, she's gonna file a lawsuit against us in a different court, that you won't be our judge, and it'll be over 25. So no money back. She didn't want to talk about the money back again, so she said escrow only. So I just leave it in your hands, Your Honor. I don't know what to do anymore.
Completely misconstruing what I said. I made up, and we didn't need to be talking about settlement matters, but I made a valid settlement.
Counselor, if you don't want to talk about it, don't talk.
Yeah.
It's not going to make a difference. I mean, you know, I'm just going to say this. Go back there and talk. Your client, I'm going to let you put the testimony on, but there are certain representations that she's made to this court that you may or may not be aware of, because you got caught with one, I'm not saying caught in the sense of whatever, of a statement that she made, which is absolutely contrary to what she said before. All right, are we ready to try this?
To be let off the case at this time?
You're looking to withdraw?
Yes. I can't reasonably represent her if I'm going to misconstrue the facts.
Well, it's not an issue of you misconstruing the facts. I'm just telling you that there are certain representations made on the record, which I will tell you were different than what was said today. And I will tell you, counsel, I can tell by your reaction that you did not know that. So if you are going to move to withdraw, I'm going to step off, and you probably need to have a detailed conversation with your client about that. The court's going to stand in recess. Everybody can remain seated.